We don't even know where the line is. And we have some people that live there that don't know if they live in Maryland or West Virginia, still to this day, all these years later. So it's not always a perfect document. It is the best document that can be prepared. And admittedly, I'm not bragging. I mean, I'm not here to build an ordinance that'll be taken statewide and I'll get on a bandwagon and go around and cheer this thing on. It's the state that is requesting. They saw what work was done in Douglas County and the pain that we went through in the process of hearing all comment and taking time and having a 7-hour public meeting where we had all comers be heard. This is undoubtedly a better product than we had in the prior ordinance.
Who in the state's looking at this?
Pardon me?
Who in the state is talking about adopting this statewide?
Well, I mean, this is...
I'm surprised to hear that because that's not what I've heard.
Well, I can tell you that I've talked to Kevin Sneed, who is he has that long title under Homeland Security, and he has personally told me that he is interested. In fact, he asked me if this ordinance is passed, if I could send it to him in a Word document so that he could utilize either all of it or portions of it to help other counties update their ordinance in a favorable way and not have to go through the 5 months of pain that we've gone through here in Douglas County.
So it's a federal official you're talking, not a state official?
No. A state official. Kevin Sneed is the Homeland Security Director of Floodplain Management. He's a technical advisor by law to all the counties in West Virginia.
Right, but isn't he a federal employee?
No.
State
employee.
Department of Homeland Security,
Okay,
West
and then
Virginia
this
State.
is a notification. How would you like to live down on the hill back of Crystal Lake and want to do something?
I apologize, ma'am. I don't know where
I
that's
said, how
at.
would you like to live on the hill back of Crystal Lake and like to do something with your property?
Well, if it's quiet and it's cool in the summer, I'd love to live there. But I don't know about going anything on my property.
See what I'm
I'd
saying?
probably sit on the porch.
No, what I'm saying is we have different areas. It's going to be ridiculous.
The example that you just gave, would you be, when you sit on the hill, you wouldn't be in the floodplain, would you?
If
You still have-
dipped over the hill and went along the highway, and you're behind Crystal Lake and around it, you could still be on the middle island.
It's only the portion of the land that falls within the FEMA recognized floodplain in the floodplain map. So it's
But
only that portion.
That you would have to notify?
Yes, it's just that portion that's affected, not the part that's outside of the floodplain area that's recognized on the FEMA maps. So if your property, you might have a portion of your property in a recognized FEMA floodplain, but you also have a portion that's not on the FEMA recognized floodplain. And if it's not on the FEMA recognized floodplain, you don't have to go through the process of getting a floodplain permit.
Well, with all due respect, I have to correct you because that's
Okay.
not this ordinance. Okay? This ordinance requires anyone that is building and using the definition of construction or development in the ordinance, anywhere in the county, you have to come forward and file a application. And part of that process will then be the floodplain administrator making a determination as to whether your project is completely outside the floodplain area. And if it is, then you don't have to do all this stuff. But again, if you remember at the elongated public meeting that we have this problem in virtually every county in West Virginia. The counties cannot afford either a helicopter or a fleet of county employees going out every day to inspect the whole county to determine whether a resident has decided to build in the floodplain. So part of the process that we've gone through, hopefully in the newspaper down here or in other public media, we are educating everyone within the county that if you're going to build in Doddridge County, you have to come to the courthouse. You have to file an application, and then your floodplain administrator will determine, are you within the floodplain area, any part of your construction or development, or are you wholly outside? If you're wholly outside, then go to it, it's all yours. But if any part is within the floodplain area, then you have to go through the full process of the ordinance.
May I ask a question about Mr. Tennant and Dan? I recall accessing a program online that indicated where the floodplains are in Doggett County.
Yes.
Does that program still exist? The public still has access to it?
Yeah, through the FEMA website, you can look at the permits and the maps and all, yes.
Okay. Has the floodplain itself been modified from what I viewed a couple of years ago? As a result of this ordinance?
I don't believe that they've done much modification on it. There are a lot of other tools out there now that have become available, not just through FEMA, but through other engineers. WVU has a deal going up here where I think they have majority of the county's map now is where, on an overview, they feel that floodplain lays. It's not officially recognized by Home Security or FEMA, but there are a lot more tools coming out there all the time that will let you view
So
where these areas
people
are.
can, if they're making decisions where to put a building, they can access ahead of time information and get input as to whether or
And
not
have
they're
a
close to
really
it.
good idea as to whether they're out of it, they're on the line, or they're in it, yeah.
Yeah, Mr. Sneed said the last time, you people should get out and mark every creek and every run so we would have better maps.
Yep, that's what I was going to ask right here. Our new floodplain maps took effect when?
October 11th, all a year ago, they was.
He said
Okay, so there has
$1,000.
been a change right there. And if our streams, like my stream, isn't on the map, who is responsible and who has to pay to have that elevation done before I do anything to my property? Who has to pay to determine?
Well, you bring the information to me, okay, on the application. I will look it over, and if there's a determination possible there, in or out, I'll make it. If it's so close that it can't be called, you're going to have an elevation certificate in order to know
And that,
whether or not it is in or not. So, you know, there are times that you're not going to be able to, and believe me, especially in the A zones on those maps, which stands for approximate, there is a lot of variances there. I've seen them be off as much as 20 or 30 feet in elevation once the field work is done. Quite often I get calls from people who flood insurance with their residence and everything now. And Kevin told you it is required by the government now that if you have a mortgage and if you are in a floodplain, you have to have flood insurance. And it appears from what I've come against that the lending institutions have outsourced that to another branch that has evolved there, where they just are looking at their maps and say, okay, here is all of the people that we have mortgages with. You tell us who's in the floodplain and who's not. And some of these outfits leave a lot to be desired.
But there is, you are not definitely required to buy your insurance off of FEMA, even though that's a
No,
lot.
There's others, I believe, that offer insurance besides FEMA. They lead you to believe that they're about the only ones, but I believe State Farm and Shirley down here and others.
I did ask this.
Yes, are also selling insurance.
one
But
other thing.
historically, I mean, the process, as I understand it, historically with FEMA is that the insurance industry, which is a private for-profit group, the costs were rising so dramatically that, and the pool of those who were insured under those costs were narrowing. And as the pool narrows of people that are buying insurance, the cost will rise. And that's what happened in the private commercial insurance industry. And so this is where government comes in. Government came in and said, we have to make this more affordable. And what government did, and I hate to use an example, like Obamacare, everyone knows what that is, they essentially enlarged the pool of people that have the opportunity to buy FEMA flood insurance, which is at a lower rate. And you have to, read that law just like you would read a private insurance policy to know what it covers and what it doesn't cover. But generally, I think you would find that the FEMA premium is much lower than private industry because the pool is much larger because it's a national pool.
And there's one other point I want to make. You talk about helicopters or a whole bunch of people going out and looking around. You don't have to do that with Google Earth. Upshur County within the last 4 years, I have witnessed their assessor actually using the internet with the man on the phone saying, when did you put that basement in? How many cows do you have out in the field? And that's how he does his assessment. He doesn't travel around the county.
And in my thoughts, this ordinance will not be a benefit to us the way it is, because it's going to cause more problems for the people who live here. And also, I even think that in the long run, it's going to help hurt the selling of property.
I don't
Don't
have any
devalue.
doubt that. It's definitely going to affect selling property.
It's going to devalue anything that's down in the floodplain because you can't use it without a bunch of regulations.
The only constructible property in Dodgers County is down in the floodplain, it seems like.
The road and the creek and the hill.
Unless you want people to spend $1 million every time they want to build a house, cut out the side of the hill.
Are you done, Dolores?
Yes, I know.
Next is Robert McHale. I'll defer. I didn't hear you.
He said he,
I'll defer, thank you.
Okay, thank you. I can't read the last name, sorry.
that's Chris Remkus. I apologize, my handwriting's atrocious, so I don't blame you at all.
Okay, all right.
We had a few comments before. I'm with Park West. We had submitted some written comments before, and I wanted to touch upon those, but I also wanted to talk about a couple of things that came up because we have talked to people at the state level, and granted, I will confess I've talked with Homeland Security folks, but this is a problem. I mean, this ordinance is something that is going to significantly affect development, and it's unnecessary. I mean, when you talk about property rights and restricting property rights, just because we throw FEMA's name around doesn't mean that you unnecessarily restrict them. Some of the language in here, if you go in and you look at the language it talks about, you cannot develop, you cannot build at all in the floodplain, that there's a reasonable alternative. Who defines what a reasonable alternative is? Is it telling them to go cut the hill down so they can put their house higher up out of the floodplain? I mean, what is a reasonable alternative? What is the dollar threshold for a reasonable alternative? Language like that to me is very troubling, because it permits government, and government wants to be obstructive to development. And given the amount of constructible property that isn't in the floodplain versus the amount of constructible property that is in it, it could significantly impact development. Also, we talk about constitutionality and things like that. I mean, if you're telling someone that they have a proposed development that is legal in all respects, but because the county thinks 15 years down the road it might build a park down the way, they can't build on their property anymore, how is that not a taking? Why doesn't someone have a problem with that? I mean, if I have a legal permit in and I have a legal right to build in the floodplain, why would it be denied because somebody may have an idea down the road? It's so broad the way this is written. This sort of stuff should be very narrowly tailored. Language that affects property rights should be very narrowly tailored. And, there is a long line of case law that talks about a government's ability to regulate property rights and to regulate the way people use their personal belongings. And we brought up zoning earlier. If you want to change the way things are done, you want to go through comprehensive zoning reviews and whatnot, that's a totally different animal. And even bringing it up in the context of floodplain ordinance is totally inappropriate. I mean, just totally and completely inappropriate. You're talking about fundamental property rights. And if we're just trying to protect someone's ability to get insurance, we need to very narrowly do this. And the changes that have been suggested by industry to date they were wholesale ignored. And I actually would have gone a lot further with it. And I would encourage the commissioners to take another look at this, because, we want people to be able to get insurance. There's no question about that. And if FEMA's demanding something be done so the folks can get insurance, sure. Let's make sure that we do something to help those folks. But likewise, let's not go too far. There's no reason to go further than the minimum necessary to satisfy getting those folks insurance. And the language in here is just so broad. It's scary. And the notification requirements, when we talk about affected residents, it's not just adjacent property. It's anybody that could flood downstream or upstream, really. I mean, you talk about the streams out here. I mean, I don't know who could be affected if I'm doing work out at the Sherwood facility, but I would assume it's a whole lot of people downstream, and the notification requirements, they're just onerous. They really are. And the suggestion this is the only way to do it legally, I don't agree with. We're happy to submit written comments again on this, to narrowly tailor them. We're happy to sit down and go over them with both your council and with you guys and try and explain why we think that you can do something a little less. We're happy to have the folks from the state come in and sit down. If the state FEMA folks or Homeland Security folks have a dog in the fight, let's get them in here and figure out how to narrowly tailor it so that the property rights of the township and the communities are protected.
Well, I'll just respond in this way. Many of the things that you just said are being directed by FEMA. That's number one. Number two, on the notification provisions, have you read Judge Sweeney's order out of Circuit Court, out of the EQT case? He has held that part of this ordinance unconstitutional. You have to give people notice if you're going to affect their property. I mean, are you a resident of Doddridge County?
I am not.
Okay, so you're from Mark West, you're from the industry. Your council submitted comment. They were not wholesale ignored. There were specific provisions that your council from Mark West that we adopted in this ordinance.
Such as?
Well, I can't recall because there's so many. At one point,
We sent a letter with 3 changes, 3 paragraphs we requested changes to. 2 of them were totally ignored.
We
So,
don't want
I mean, we can debate.
in baseball terms, you'd be in the Hall of Fame. I mean, here's the thing. Unfortunately, I sat here contemplating the fact that this is interesting because the ordinance really is to protect the residents of Doddridge County. And it is odd, but because I'm surprised that there's opposition to the ordinance by landowners who are residents of Doddridge County. That kind of surprised me. It's a little bit like you'll see every once in a while you'll propose a piece of legislation and there will be very opposed entities that will become bed partners on the piece of legislation that you might not have anticipated. But basically what you're saying to this group is, you're Mark West, you're the industry, and you want these people to believe that you have their interest at heart as property owners, right?
Not only do I want them to believe that, it's absolutely true.
Yeah, then what you need to do is you need to go to Congress and have them affect legislation change or regulation change with CFR from the national level, or you need to go to the state of West Virginia and pass a statute, and you need to sit down and talk to Kevin Steen. He has been intimately involved in reading these drafts, intimately involved in negotiating the language that would be acceptable to the state under his direction, and intimately involved in a 3-hour conversation that we had by teleconference to FEMA in the regional office in Philadelphia. So, I know you came late to the dance, but you need to get updated on what's gone on to this point with respect to this ordinance. This has been a 5-month process. Okay, you came to the dance in the last month. A lot of what you're suggesting has been done. You just don't know it.
Well, I'm talking about
Okay. Let's keep order. He has the floor, okay?
My
Go ahead,
problem with this is the suggestion that language that says, if there's any reasonable alternative, I can't build in the floodplain.
Okay,
That is not-
number one, you're wrong. Okay, I hate to interrupt people, but I can't allow
Then
you
don't
to
interrupt someone. If you
promulgate
don't-
something that's wrong. It is floodway, not floodplain.
Okay.
Okay,
Either
that's
way.
a different animal. A
Either
floodway is a defined geography of a stream, a river, and that is the language that you're referring to with respect to a reasonable alternative. It's not the floodplain generally.
Again, a standard that says if there's a reasonable alternative, you can't do it. It is a standard that gives no protection at all to a landowner. And again, the suggestion that from a use standpoint, that the use of your property is going to be contingent upon things that could be anticipated uses is difficult to swallow. And to say that just because we're industry, we don't care is ridiculous. We come in and bring jobs, we bring money, and we buy property. We have bought property. We want to be able to build on it consistent with our rights right now. And to say that, I talked to FEMA, and this is what they want it drafted, I want to see the statute that says it has to read this way. You say I have to go get new law. I don't need new law.
Yeah.
I have plenty of counties, not just in the state of West Virginia, all over, that don't have language like this. And so you're saying that it's illegal not to have language like this. I don't agree with that.
Well, the reasonable alternative language is not language that we came up with here in Doddridge County. That's language that came from FEMA.
That's great.
Okay.
Why don't I let the EPA just tell me, you guys have the EPA write your laws and see what they come up with for their reasonable ideas. The suggestion that things that they want are what are absolutely required is wrong.
Well, it's odd because admittedly there are certain pieces of language that I thought were odd, okay? And I attempted even inconsistencies between one section to another section with respect to the usage of words. And I suggested that it be changed, so rather than it being development in one section and construction in the other section, I said, why don't we just use one word, either construction or development? I don't care which, but why don't we get this straightened out? And when I went to FEMA to get the approval of that change, they go, oh no, cannot do that. It's in the CFR. You look at CFR, yada, 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 and that's the language of the Federal Code of Federal Regulations. So I feel your pain, but you're preaching to the wrong choir. You need to preach to Congress to get these changed. You're big enough with your industry to go to Congress and get that changed with all the lobbyists that you have in Washington, D.C.
There is not language in the CFR or in FEMA's regulations that specifies it be written this way. There isn't. You may have talked to them on the phone and they suggested they like it. There is not language that says it has to be written this way. We wouldn't propose language that we thought would be illegal. We are a heavily regulated industry. We are an industry that is under a microscope. We're not going to do something that we think is going to run afoul of the law. My suggestion that we sit down and at least have our comments taken more seriously. I mean, you can say you took them into account, you ignored them. And to be able to be at the round table and talk about it, the only reason we came in a month ago is that's when we heard about it. We didn't know about it before then. You know, for better or worse, we didn't. And you know, we aren't the only ones in the industry that relate to the table, but we are significant property holders. We are pumping significant dollars into these communities. But you know, this county, I just sat down with a property owner today and gave me a history lesson of the finances of parts of West Virginia. And that this county, before the introduction of the oil and gas and the shale boom, was struggling.
That's every county in West Virginia.
That's exactly right. The point is, you can't stymie industry. The way this ordinance is written, when you have a producer suggesting you can't do business here.
That's not true. It's not true that this will stymie business.
How do you know that? Well, you make that statement. You think business has time to send people out here, and the business tries to interrupt the legislative process solely to make mischief?
Yeah, but
we are very heavily regulated.
The thesis of your argument was attempting to incite this crowd to believe that this was a landowner's issue on an individualized basis.
Yes, we're the landowner.
Yeah.
I'm talking about building on our property.
Yeah.
It is
and you want no regulation, you want no rules, so you can do what you please.
There already
and,
are.
and that's unreasonable. It's unreasonable.
The suggestion that we don't want rules is ridiculous. We're happy to sit down and go over them.
Excuse me for 1 minute.
No problem.
We have a 5-minute limit on public comment, and
But no problem.
I have not enforced that.
That's no problem.
But I am now, okay. So I'll just ask you to
That's fine.
say your final 3 words.
If we could just submit some written comments and you take a look at them, I'd appreciate it.
Jim?
I would ask Mark West, have you filled in the floodplain that's where your present facility is? And number 2, do you have a stormwater management permit? No, you don't. Not out today, you did not have one.
For ongoing construction, we would, yes.
It would be on file, and it's not on file with the DNR. I would go back and look at the law.
The DNR just passed, the DEP just passed the stormwater permit process. When they were under construction, we only asked the facilities for exempt from having stormwater permits. Not until this year when the DEP passed that.
Mr. Rehnquist, does Mark West have a floodplain permit for the facility at Sherwood?
When you say a floodplain permit, I'm not sure that facility right now is actually down in the flood.
It actually is. The loading dock actually is. It actually is.
I don't do construction, I don't do dirt work, and I don't do the permitting form, so I don't know the answer to that, but I'd be happy to get it for you.
It is in the floodplain permit. If those maps are correct, it is.
Okay.
Where you load the propane and
That's right.
liquefied
That's
natural
right. The
gas,
truck
that is
loading,
in
right.
the floodplain. And where that's located is upstream of the West Union water supply. So anything that happens there ends up in the waters that run through our water plant.
That's heavily regulated by the state and the federal government from a water discharge standpoint.
Also, are the septic tanks up that way?
That's right.
May I comment on that for a second? They did acquire a permit. They had either the one right before or the one right after, the one out in the stops right there. It happened right at the very same time. They did have an original permit, okay? When they started building a bridge and the tank facility there now, along the old rail trail and all, I came to them and said, well, I need to see some work on this, guys. They gave me a good head crack study and all there. The effects were very, very minimal. So,
Mr. Robinson would like to make a comment.
You know, relating to something you said, and in all fairness, I've heard this from both sides of this argument, is that comments weren't considered. It seems like both sides think that if your comments aren't adopted, that it wasn't considered. So, you know, that's my comment. You know, it doesn't mean that it wasn't considered. It just means that it was looked at and a determination was made. That's my comment.
Okay. Public comment is over.